Good afternoon, everybody. Welcome to Taking the State to Court. I am super excited right now to have the two gentlemen behind me in this room. They really need no introduction. I could sit here and tell you, list their long line of accomplishments that inspire only admiration. I don't want to waste too much time. There, right now, in Minnesota courts, there is a class action lawsuit that seeks to, well, I don't want to say too much, but truly end racial segregation in our schools in this state. And we are honored to have the two gentlemen leading that charge, our very own Professor Orfield and Mr. Daniel Shulman. So he'll join me in welcoming them, and I'm going to turn it over to them.
Well, I'll start. I'm Dan Shulman. I've been a trial lawyer for 48 years. I do what I really know something about is antitrust law, but I do a lot of pro bono civil rights law. And it's very, very important and exciting for me to be here to talk to you because you are the future of law in this state and everywhere you go. So, with all that said, the case I have now is called Cruz-Guzman versus the state of Minnesota. It is brought under the Minnesota Constitution, the Education Clause, the Equal Protection Clause, and the Due Process Clause. Now, I'm going to give you some history and some background first. I must acknowledge Professor Orfield from Myron. I've known him forever. He is instrumental in this lawsuit. He is instrumental in efforts to fight segregation in schools and housing in this state and elsewhere. And he's made a career out of it. And he is an amazing, very important person in this field. So here's a little bit of history. I don't know if you're aware of it, but Minnesota, Minneapolis, and St. Paul, in terms of schools, are among the most segregated school districts in the United States. Minnesota has one of the largest gaps between income and wealth between black and white in the United States. And this is not something new. Of course, it's gotten worse over the last 20 years. But I started practicing law in 1970. In 1968, well, of course, in 1954, Brown versus Ford was decided, where they said separate's not equal, and overruled Plessy v. Ferguson, and started a wave of desegregation in the United States. In 1968, or 69, and I'm one of the two, a desegregation case was brought in the federal court of Minneapolis, and on behalf of essentially the NAACP. That case was decided in 1972. The plaintiffs won. The court found intentional segregation by the Minneapolis School District. The suit was against the Minneapolis School District under federal law for violation of equal protection. The court ordered desegregation in Minneapolis, which in fact occurred. There were with substantial busing, kids going back and forth, and the court retained jurisdiction over that case for approximately 10 years. It relinquished jurisdiction because the state of Minnesota Department of Education filed a paper with the court promising that it would make sure that Minneapolis complied with its desegregation obligations. Now we jump forward to the 1980s, and by that time there's been a significant shift in the law in federal court. Essentially, the Supreme Court had taken all the teeth out of Brown, and the federal And subsequently, of course, the federal courts became much more conservative, much more inhospitable to desegregation cases. What happened around this time, late 80s, early 90s, was that people discovered another way to attack this. Under the United States Constitution, there's no right to an education. None. Almost every state, however, has in its constitution an education clause. The state of Minnesota, the clause that it has is that the legislature shall create a system of general and uniform public schools and provide funding so that this system of schools can be thorough and efficient. These are very important words: general, uniform, thorough, and efficient. So, and a lot of other states, I would say the majority of them, have education clauses that are quite similar, if not identical. So beginning in the early 90s, late 80s, people began to file what they call these cases in state courts, challenging inequitability of funding and, to some extent, desegregation. And the leading case was filed in Connecticut. It's called Sheff, S-H-E-F-F, versus the state of Connecticut. And it might still be going. We'll get to that later. Anyway, so in 1995, I was approached by the Minneapolis branch of the NAACP, and kind of Myron's predecessor here, John Powell, who was running the Institute for Race and Poverty. They asked if I'd be willing to file a case, and I did pro bono on behalf of a class of Minneapolis school children. The plaintiff was the Minneapolis branch of the NAACP. And I filed that in 1995 saying the Minneapolis schools are segregated because they had resegregated by that time. From 1972 to 1995, the situation had become worse. I said, under Brown, schools are segregated. Now, another fact, in 1993, the Minnesota Supreme Court decided a case called Skeen, S-K-E-E-N, versus the state of Minnesota. And that was a case, and I should tell you, most of these so-called adequacy cases were about funding and inequities in funding. And the plaintiff, and that was what the Skeen case was about, and the plaintiffs conceded they were getting an adequate education, but said the funding was not equitable. Because of that concession, they lost the case. And there's a very important principle that comes out of that, which is that adequacy of education and sufficiency of funding are two sides of the same coin. They are inextricably linked because you can't determine whether funding is sufficient unless you know that it's producing an adequate education. So the Minnesota Supreme Court in Skeen went beyond the result I told you about because there was an equal protection clause claim. And they found that students in Minnesota that the legislature was required to provide children in Minnesota with an adequate education. And what's more, that right of students to an adequate education was a fundamental right, which is a magic word. Fundamental is a magic word in basically due process litigation, because when you go from, if it's a fundamental right, you go from rational basis analysis, which basically allows just about any justification, to strict scrutiny, which allows almost no justifications if you're tampering with a fundamental right. And also, you get rid of any showing of discriminatory intent with a fundamental right. So in that context, we brought the case in 1995. We said Brown said that separate isn't equal. We've got separate segregated schools here. If it's separate and unequal, then it can't be adequate, and it violates the Minnesota State Constitution. It also violates equal protection and due process. The state moved to dismiss the case, lost the motion, tried to get an interlocutory appeal, a discretionary appeal to the Supreme Court, Minnesota Supreme Court. The Supreme Court turned it down and said, we want to see a complete record here so that we can make a truly informed decision. We litigated that case for 5 years and settled it in 2000. The settlement, the big piece of the settlement was a program called The Choice Is Yours. The Choice Is Yours, for a period of 4 years, allowed 500 kindergarten-age children in Minneapolis each year on free or reduced lunch. That's important. It wasn't racist. It was free or reduced lunch to enroll in participating suburban school districts. The state paid for the transportation. Once these kids entered kindergarten in one of these suburban districts, they could remain in the district until they graduated from high school. In one form or another, it was supposed to be a 4-year program. In one form or another, it's still around, and there are times when it has been very, very successful. Now, why did I settle the case? I settled the case for 2 reasons. One is, one of the problems with these cases, adequacy cases, is the remedy you get. And I'll tell you more about that, but basically the remedy is the court says that the state is violating its constitutional duty, and as a judgment, you are violating your constitutional duty to provide either an adequate, desegregated, equitably funded education. You are enjoined to stop the violation, and you are ordered to correct it, which means it's not the court that fashions the remedy, it's the legislature. And there's good news and bad news with these cases, because as often the history of these cases is that you run into legislatures all over the country. This has happened, that are basically recalcitrant, reluctant to do anything, so that they pass some kind of legislation. It's not sufficient. Plaintiffs have to go back to the court, say this is not, it doesn't cure the problem, it doesn't comply with your order, so they have to do it again and again and again. For example, Chef, that's where they are with a case that was brought in like 1990. They're still, fine-tuning, getting the and Kansas has kind of the same situation. So that's the first reason we settled. The second is we thought, let's take a meaningful first step to desegregation, and let's see if it starts, if it creates a tailwind and really starts so that we get total desegregation integration. Well, it wasn't, and it didn't. I mean, in fact, by about 2012 or 10, things were worse than they were before I filed that first case. So I let it be known to people in the community who were interested in this, that if somebody brought me plaintiffs, people willing to be named plaintiffs, I would file the same suit again, class action, and this time, we're going to get a judgment. We're going to get metro-wide desegregation, because, and I'll talk about that more, that is the only workable solution to this intractable problem of segregation. So I brought the case, same claims. The state again moved to dismiss. The state again lost. This time, they were a little brighter than last time. They said one of the grounds was there's no jurisdiction, subject matter jurisdiction. Under state law, if that's the claim you make on a motion and your motion's denied, you get an appeal of right. So the state had an appeal of right to the Minnesota Court of Appeals, which they took. Unfortunately, we had a very bad draw on the panel and got use a legal term, a really horseshit opinion. basically, and the way, and it threw the whole case out, this decision. What it said was, because one of the concepts, and I don't know if you've encountered it yet, is called justiciability, which means there are two aspects to it. One is that this is not something courts are equipped to deal with, and two, this is something that would cause, if the court did deal with it, it would cause the court to impinge and usurp the prerogative of another branch of government, typically the legislature. Now, this issue had been litigated previously in like 27 states. 22 of these states said this is justiciable. This is what courts are supposed to do. Five of them said it's not. And in every one of those 5 states, the education clause in the Constitution was much less imperative than Minnesota's. And, you know, it was more what we, go back to my old Latin, it was what we call hortatory, urging the state. The state shall endeavor to establish a system of public schools. In other words, in scheme, the Minnesota Supreme Court said this is a mandate on the legislature. In fact, it is the only mandate on the legislature in the entire Constitution. So, anyway, and in this opinion, very intellectually dishonest. They didn't cite any of the law from the 22 states that were our way. They cited only the 5 states that supported the result. So, within days, I drafted a petition to the Minnesota Supreme Court for discretionary review, which was granted, and I argued it on January 8th. You can see the oral argument online at the Minnesota Supreme Court's website. And on July 25, the case was decided, and we won on everything. And there are 2 key parts of this opinion. One is in footnote 6, where the Minnesota Supreme Court said, it is self-evident that a segregated education is not general, uniform, thorough, or efficient. How about that? This is the first state Supreme Court in the United States to make a statement like that, and that should provide wings to these cases all over the country. I mean, and to me, that's a silver bullet, and I don't know how the state thinks it's going to get out of this. And the second thing was, the court said the district court has to, in terms of what the district court is going to do, first of all, well, it said, justiciability. This is what courts do. They construe statutes and constitutional provisions to see, and they decide whether they're being complied with. What's the mystery about that? That's why we have judges and courts. So clearly justiciable. And they said, and this is the second thing that's really significant, the district court will be required to answer a yes or no question. Is the legislature providing an education that is general, uniform, thorough, or efficient? And if it's not, you tell them to fix it. So that is, and right now we are briefing. We have a trial date, by the way, in this case in January of 2020. So 15 months from now, which is quick for one of these cases. And right now we're litigating the class certification, which the state is imposing just because the position of the state is if I want it, they don't. Because think about it, class action, if it's certified and the state wins, everybody, all the kids in Minneapolis and St. Paul and their families are precluded by res judicata from bringing a similar claim or the same claim. If they lose, And if the class is not certified, and the state wins, then no one is barred. I mean, I'll bring the same case tomorrow, if that happens, the next day if that happens, for somebody else. And we'll find a judge that will rule for us. No matter how, as I say, I don't lose cases, I just run out of courts. So right now we're briefing class certification. That is going to be heard at 9 o'clock Tuesday next week in the Hennepin County Government Center. It's open to the public, so if you would like to see, a court hearing, feel free to show up. So I'm going to let Myron take over now, and then I want to talk about, why we want Metro Lighting segregation.
Okay, I'm just going to talk for a few minutes. This is really Dan's show. Dan is a fabulous part of Minnesota history. He's really been in the trenches, paying his own bills, these cases for as long as I remember, since I was a young man, as a summer clerk in his law firm, way back when. Very briefly, when I was a summer associate, I handled the NAACP's administrative work when I was an associate at Faber and Benson. I had to quit because I got elected to the legislature, and I knew they were going to sue the legislature, so I couldn't represent somebody that was going to sue me at the same time. But I couldn't handle any of this at that time at 26 years old anyway. I also have a perspective. I'm the Earl R. Larson Professor in Civil Rights Law, and Earl R. Larson desegregated Minneapolis schools. I was a product of desegregation, so my high school was desegregated by Earl R. Larson. I went to Washburn High School, which had not the court ordered, it would have been all white. Going to this integrated school was a fabulous experience for me. So I'm a product of that ruling in the 1970s. Really changed my life in lots of ways. One of the reasons I'm here is because my high school was desegregated under court order. And it was a fabulous thing. I go to my 40th reunion this year, and it's a rich, wonderful experience. And most people that went to integrated schools have that same experience. It's been studied. I think one of the most important things to think about in Dan's lawsuit is, as Dan was settling the Jean case, the first case, there was a very rapid and transformative change in the way the Minnesota Attorney General construed the law. Up until 1998, Minnesota had barred de facto segregation. So Minnesota, under the Minnesota Human Rights Act, it was drafted by one of the deans of this law school. I wish I could turn this off, it's broken. Under the Minnesota Human Rights Act, together with an 1868 statute that prohibited segregation in Minnesota schools, then administrative law judge George Beck had held that Minnesota had the power to outlaw de facto segregation. So this was a court case that time. And up until that time, the Attorney General of Minnesota held that position, that the Minnesota law supported the forbidding of de facto segregation. Suddenly, 2 weeks after the gubernatorial primary, the Attorney General changed their opinion 180 degrees from one that said Minnesota had the power and authority to decide court law to outlaw de facto segregation, to saying that looking at the tea leaves, looking at what the Supreme Court might do, it's likely that there's no compelling interest in racial integration. Therefore, voluntary integration is presumptively illegal. So it went from being as progressive as you can be, possibly, to becoming a position that was to the right of any decision of the U.S. Supreme Court. Now, there was a period of time when people worried that the Supreme Court might say something like that. They might say that voluntary integration was like affirmative action. There were law professors, there weren't any law professors, there were some commentators that said this, right-wing think tanks said this would happen. There were people on the Supreme Court, Clarence Thomas, who made noises like this, but the Supreme Court never said there was no compelling interest in integration. In fact, just the opposite. In 2007, Justice Kennedy made clear beyond all doubt that there is a compelling interest in racial integration, parents involved. But this opinion that the Attorney General wrote in 1998, Hubert Humphrey's son, changed the playing field. And that same opinion presumptively forbid voluntary integration and exempted charter schools from regulation, which had been heretofore regulated by the desegregation rule, and exempted open enrollment. And after that, the segregation of schools just skyrocketed. Charters being a driving force, open enrollment being a driving force. So you have this really powerful opinion that changed 180 degrees with really no legal authority. There wasn't a single federal case that supported what the Attorney General had done. They cited one case, the Hofeld case, in which the Fifth Circuit had held that affirmative action in higher education was illegal. And that was an outlying opinion that was reversed by the Supreme Court in Gruber. In the Eighth Circuit, there was clear authority that there was a compelling interest in integration. The Supreme Court of the United States had 4 times said that voluntary integration was not only allowable, but that it should receive every encouragement of the federal courts. In Swan and 3 other cases the same day, none of those cases were cited by the Attorney General's opinion. So a lawless opinion, without any basis, uncorrected over a long period of time, has produced a very rapid change. In 1993, there was not a single segregated school in the metro area. Last year, there were 110 elementary schools that were more than 90% non-white and poor, really all terrible schools. All the schools that weren't leading toward opportunity were leading toward the criminal justice system for young men more than college. So there's a big change. You've got a position, you've got a legal position that had a very powerful role in it. It was a lawless opinion, really. There's no authority for it. And it had a big effect, and it was never corrected. So I think that's an important piece to think about in this larger scheme of things. And I'm going to sit down.
Well, that raises a question about proving intent in this case, whether we have to prove intent by the state to allow or create segregated schools. We think that under the Education Clause claim, because we have a fundamental right, we don't have to do that. And that both the district court and the Supreme Court's opinion, I think, supports that, although they did not directly address it. In the equal protection claim, the district court said that we did have to prove intent, but said that our complaint sufficiently alleged intent by the state. And what Myron told you about just now, if that is an intent, you know, the law said there's a maxim in the law that's one intends the consequences of one's actions. I mean, the effect of this opinion is so obviously foreseeable that I don't see how they can deny culpability for it. And of course, he also mentioned what they've done for charter schools. Exempting charter schools from desegregation rules is unique in the United States. We don't know any other state where that's occurred. Open enrollment has been a huge thing because the state isn't paying for the transportation. So who open enrolls? Who gets to do that? Rich kids. And the other thing that they did was allowed Minneapolis and St. Paul to revert to neighborhood schools. Now, and that raises the whole issue about housing and de facto versus de jure segregation. In my opinion, there's no such thing as de facto segregation in this country, especially housing, because segregation in housing is the result of more than a century of action by the federal, state, and local governments to segregate minorities in housing patterns. And I mean, and it wasn't, if you read about it, you'll see, this wasn't inadvertent or simple neglect. This was intentional. I mean, some of these developments and laws permitting housing, you know, government-supported housing, required segregation in the housing. There's a book called, I think it's The Color of the Law, that reviews the whole thing. Anyway, so why do we want metro-wide desegregation? First of all, for a number of reasons. First of all, and I should tell you, there is no amount of money that could ever get me to settle this case. None. I want a judgment that these people, the state, has segregated schools in violation of the law, and that they be required to fix it. Now, if they came with a metro-wide desegregation plan that made sense, with all of the other accoutrements, subsidiary things that are needed to make it work, such as ways to prevent what's called secondary segregation or second-line segregation, where minority kids are put in supposedly desegregated schools, but there's segregation within the schools. We can't have that. We also can't have all-white teachers teaching. You know, one of the things that might make this work is magnet schools. And desegregation is the only thing that has been shown to work in terms of closing the achievement gap in a meaningful way. And it has been done on a metro-wide basis. I know Raleigh, Durham, Myron.
Louisville, there's 16 places that have adopted.
And why metro-wide? Why does it have to be metro-wide? Because one of the arguments against desegregation is if you do it, there's going to be white flight. We're going to lose all the white parents and their children. Well, think about it. Metro-wide desegregation in the in the 7-county area. People don't like it. Where are they going to go? They can leave Minnesota. Are they going to go to International Falls? Are they going to go to Bemidji? Are they going to go to Owatonna? And let's talk about busing too, because you know that is one. And then I'm going to talk about charter schools.
Been a lot of massive questions too.
What?
You better a lot of massive.
Yes, please. Anybody with a question, just shoot your hand up. I'll take any question anytime. Okay, busing. People always say, well, is there going to be busing? Busing is a dog whistle about racism. Because almost every kid rides a bus. Think about, people say, oh yeah, no, I'm against busing. Okay, let's make it a felony for any child to get on a school bus in the state of Minnesota if you're really against it. You okay? Would you be okay with that? And let's, we need neighborhood schools. Let's talk about, is Blake a neighborhood school? Is Breck a neighborhood school? Is St. Paul Academy a neighborhood school? And you can list all these private schools where they draw kids from everywhere. Doesn't matter about the transportation. Why? Because kids get a good education and because they're set up for life. Because they do this. Because they make the connections. They learn about where the power is, how it works. They have the friends they can network with when they grow up. One of the things I'll tell you how we're going to prove this case. We're going to prove it with the data, which I don't know if you've seen our complaint, but it's all in the complaint. Now we've updated it. We're going to prove it with data because the data doesn't lie about where the segregation is. We're going to prove it with experts. There's one of our we have like 7 or 8 experts from all over the country. People who have spent their lives, their professional careers, studying this stuff. And they're all testifying for us at no charge. That's how important this case is. One of the experts we have is a fellow named Rucker Johnson, who is at Berkeley. He is the son of the woman who was the superintendent of schools when I brought the first case. He has spent his career studying the effects of segregation and desegregation. And he has written a paper entitled Long Run. It was published in 2011, revised in 2015. He's going to testify. His paper is called Long Run Impacts of School Desegregation and School Quality on Adult Attainment. Adult attainment. Well, this is it. He says, this paper investigates, this is the abstract. That's a paragraph. This paper investigates the long-run impacts of court-ordered school desegregation on an array of adult socioeconomic and health outcomes. The study analyzes the trajectories of children born between 1945 and 1968 and followed through 2013. I was born in 1944, my wife in 45, so she wasn't in the study, and I couldn't. Anyway, I exploit, then he says, there's some technical stuff. What he does is he studies the effects of these children. There are tens of thousands of them, born between 45 and 68, going to desegregated schools. Here's what he finds. Event study analysis, whatever that is, as well as 2 SLS and sibling difference estimates indicate that school desegregation and the accompanied increases in school quality. I'll stop there, because one of the things that happens with metro-wide desegregation is an improvement in school quality in the schools that were not performing, and that is because money follows the white kids. And legislators know, people know that to make this work, they do need to invest. But you can't, the investment alone without the desegregation is pointless. And it hasn't worked. Okay. Anyway, the results indicate that school desegregation and the accompanied increases in school quality resulted in significant improvements in adult attainment for blacks. I find that for blacks, school desegregation significantly increased both educational and occupational attainments, college quality, and adult earnings, reduced the probability of incarceration, and improved adult health status. Improved adult health status. Now, what more can you ask from an education in that your health is better for the rest of your life? If your health is better, it means you're happier, you're doing better, you're more satisfied with your life. Not always, but that is, that alone should convince people that we need to desegregate and what then the benefits are. Anyway, he's one of our experts. We have another expert, Sean Reardon, he's Berkeley or Stanford, who has done the same kind of study, again, tens of thousands of students, and got similar results. When one of the things he has found is that one of the key indicators is that you reduce the concentration in a school of children basically on free or reduced lunch in poverty. And the segregation here is not just race, it's socioeconomic status. It's concentrations of students on free or reduced lunch. If you reduce that, everything improves for these kids. Yes?
Okay, so I just have a really quick question. I know that you have intended for this case to be like one fell swoop, like wholesale change, because the incremental change wasn't quite cutting it. And you also mentioned second line segregation. I'm wondering, is this intent, are you hoping that this also affects third line segregation, like disproportionate suspension and expulsion? Like,
absolutely.
How far deep into
absolutely
does that go?
It's got to be, it's got to be real integration where the school population within reasonable limits represents the demographics of the area that the school serves, where the opportunities are the same for everyone, and where there is no indication of segregation.
One of the things is that suspension rates are the highest in segregated schools. There are multiple, Black and Latino children are treated unfairly in almost all settings. But if you look at when the rates skyrocket to astronomical numbers, the segregated public schools are extraordinarily high. Segregated charter schools are almost twice as high. And so if you're really looking at these numbers, they're bad everywhere. Nobody's good. Nobody treats people fairly in the society the way that they should be. But where they really go off the charts are in a deeply segregated setting, and it's used as a method to control kids in a very wicked way. It happens.
I should tell you, my daughter, who's African American, is the principal of Van Watten Middle School in Minneapolis. She is in her 3rd year as principal. When she took over that school, which has 600 kids, the year before there were 700 suspensions. And this is a school that's over 90% minority and free-range. She has cut that. I mean, I believe she's well under 200, maybe down to 100. But that's, that is the system that we've got that has to be fixed. So another one of our experts is a woman named Deborah Satz from Stanford, who is now the Dean of the Faculty of Arts and Sciences. She is a philosopher who specializes in ethics. And the reason that I contacted her is that I read an article where she explained quite convincingly why segregation is unethical and morally wrong. Regardless of, the education that kids get. So, and I think that's a very important point to make to the court. This will be a court trial, not a jury trial, because we seek equitable relief. And as I'm sure you all know from civil procedure, you don't get a jury with an equitable claim. Now, charter schools. One of the first things that happened after we filed the lawsuit is that a group of charter schools moved to intervene. I oppose that, lost, they're in the case. All that means is they can say whatever they want to try to derail us. So far, they haven't had any effect on us, except we have to deal with their, I was going to say nonsense, I won't say nonsense, with their filings. Okay, what about charter schools? Well, what they do is, there are a couple of things about charter schools. Number one is that it's a jobs program for a lot of people who are putting their interests ahead of the kids. Number two, they like to hide behind parent choice. Say, well, we're in favor of parent choice. You know what? I'm in favor of parent choice too. I don't want it within, reasonable limits, because individual freedoms most of them at some point have to give way to state imperatives. But I'm in favor of parent choice. I think all parents should be free to decide where their children should go to get their education. I'm not going to criticize any parent, with the exception of white segregation academies, which some of these charter schools are, who decide we want our children, we think they're going to be better educated here. And the reason is the incidence of an inadequate education falls 100% on the victim, the child. You're talking about taking away life chances. You're talking about creating bars and shackles, because this is an incident of slavery, segregation. An inadequate education destroys a child's life. So the incidence of an inadequate education falls 100% on the kid and 0% on those responsible. And that has to change. That has to change. Now, so what about parent choice? Well, today, parents have the choice. Parents, we're for parent choice, only it's got to be reasonable, equitable, and good choices. Not, do I choose between a segregated public school or a segregated charter school? That's no good. That has to change. So, anyway, we're going to try, as I say, we're going to try this case with data. We're going to try it with experts, and there are like 3 or 4 more that I haven't mentioned that I won't go into. And then it's going to be, and then we've got this evidence that Myron's talking about, the history of what happened. And Myron's going to be testifying about that because he lived it and fought it. when he was a legislator. He was there, but and then, you know, anecdotal evidence, where I think I've got people who are going to talk about how money's been misused, that should have been used for desegregation. The person who wrote who changed the segregation rule, we're going to take her deposition. She happens to be an attorney of record for the charter schools in this case. You know, maybe she should read the canons of ethics. I won't go into that, but there is the mention of when a lawyer can be a witness in a case.
There are some interesting canon issues. There was an opinion issued by the Justice Department during the torture cases, and they outlined the responsibilities of an attorney general for issuing the legal opinion. And they said one of the fundamental issues in that torture case is that attorneys had an obligation to discuss all the controlling precedents. That was an ethical violation in and of itself if you didn't discuss the controlling law. And in this case, that attorney that wrote this opinion or was involved in it didn't discuss 4 United States Supreme Court cases or a state of Minnesota administrative decision that were directly on point and had been discussed in the last Attorney General's opinion. So if that ethical opinion of the Justice Department that was issued in 2008 about torture has any guidance in Minnesota, that opinion in and of itself is a violation of legal ethics, is a violation of the Code of Ethics.
So he just gave me another half hour of questions. Okay, so that's where we're going with the lawsuit. I mean, actually, if the judge told me I had to try the case next week, I could do it. I would do it. Because, you know, by taking this appeal, we filed the case November 7, 2015. They took this appeal in 2016, and they put 2 years on this case by doing that. Now, I'm older. It hasn't affected me, but it's affected tens of thousands. It's not right. I tried to get they made a motion to stay everything during the appeal. I opposed it. The judge entered the stay, I'm sorry to say, because that's usually what happens. It would be rare for that not to have occurred. And, you know, so I said, you know, they've deprived kids of an adequate education now for 2 more years. So they wanted to try this, they wanted to set a trial date 2 years from now, or more than 2 years. And the judge adopted my schedule. They also, more or less, they also wanted the judge to stay all discovery and every other kind of pretrial preparation until the class motion was decided. I opposed it. I said to the judge, you know, if you deny the class, I'm not going to end the case. I'm going ahead anyway. So, you know, and the judge wouldn't stay anything. So we're in discovery. But I got enough bullets to try this case now, especially the statement that it is self-evident that a segregated education is not general, uniform, thorough, or efficient. I have a little memory thing for that. GUTE, G-U-T-E. General, uniform, thorough, efficient, adequate, and fundamental. Those are my key words for this case. So, and we want to try it. I mean, I really want to try this case. I love to try cases. It's the most fun thing that I do in my practice. So, you know, if I have me try the case, I'll say, don't throw me in the briar patch. So, I don't know, Myron, I'll give way to you. Any questions, please, if you have questions.
Just to give you guys a heads up, I think we've got about 2 more minutes, so there's time.
So I far better than time.
That's all right. That's all right. I get the dark one.
Could you, and so my apologies if I missed this, I came in late. Could you talk a little bit about how you thought about the class and picking the named plaintiffs and sort of what were your considerations when you did that?
Well, the class I want is all students enrolled during the pendency of the lawsuit in the Minneapolis and St. Paul school districts. No charter school kids in the class. Now, I know there are white kids that are going to be in this class, but this is a class that has been certified repeatedly in other cases. In fact, it is the class that was certified in 1972 by Judge Larson. Judge Larson was a neighbor of mine. I used to ride on the bus with him. He was a great judge. He used to do this little walk jog around Lake of the Isles. And our house was nearby, so he used to stop in the summer when we were sitting out on the porch and have 2 beers with us. His wife wouldn't let him do it when he got home. And also, you know, are there parents whose kids are in this class and the parents are opposed to desegregation, are happy with what I call the illegal status quo? I'm sure there are, but there's a lot of law that says that that does not stop certification. That is not a valid basis to deny certification. Also, this is a 23B2, or in Minnesota it would be 23.02B class, which is equitable only, which means that you don't have to have a rigorous, precise class definition. We've also, it's not required to give notice to the judge. It's within the judge's discretion, and there's no opt-out. And so, I mean, and the Supreme Court has said in the Walmart case, the Dukes case, that 23B2 was made for civil rights discrimination cases. Yes?
I know you mentioned some of the evidence you're giving us, like harms to Black children, Hispanic children
Right.
of desegregation. Are you including anything in that on harms to white children from being
Yes,
in?
I didn't read you the last sentence of, well, I mean, there's, this is a little off the point. The evidence we're going to present about the benefits of desegregation, it says the results suggest that the mechanisms through school desegregation led to beneficial adult attainment outcomes for Blacks, including improvement in access to school resources. Oh wait, there's something, oh here we go. And the desegregation had no adverse effect on whites across each of these outcomes. But, I mean, yeah, we're gonna, I think it's, as the Supreme Court said, it's self-evident that desegregation benefits everyone. And yeah, we'll have testimony about it. Yes?
Could you talk about the named plaintiffs and who they
Yes.
are, where they're from?
The named plaintiffs, the lead plaintiff, Alex Cruz-Guzman, he is in St. Paul. He happens to have been a friend of my son's, somebody I've known too. That's not going to disqualify him as a pleasure. And then 4 or 5 other parents from Minneapolis who heard about the case through the grapevine and wanted to participate. And then we have one organization, which is a non-profit corporation that helps, basically helps homeless people, and including finding appropriate schools for their kids. So those are the plaintiffs. Alex Guzman, he is a Latino. All the other plaintiffs are African.
I'm sure
Oh, and in the first case, we had white parents also as plaintiffs. So, I mean, if any white parents had approached me, yes, I would have.
I'm sure I speak for everyone. We just want to thank you for sharing your time with us. It's fascinating. We're hoping for a great outcome in the case. Thank you.
Future, you can make a difference. That's why you're in law school. You learn where the gears are, how they turn, how you can make it, and how you can stop it.